Welcome, everyone. We're going to be starting at 1 p.m. So it is 1 o'clock, so we will go ahead and begin. I want to say hi to everyone and thank you for joining us today for the Coercive and Controlling Abusive Behavior webinar. My name is Stephanie Nunley and my pronouns are she, her. I am the Training and Event Coordinator here at MOVA. I'll quickly review some logistics before passing it over to our presenters. This is a Zoom webinar, so you cannot be seen or heard as an audience member, but you can see the presenters, ASL interpreters, and presentation. If you have any questions during the presentation, please use the Q&A function to ask them. We will answer the questions at the end of the presentation. We do have ASL interpretation and CART captioning available during today's session. To see the closed captions, go to the bottom of the screen, click the arrow next to closed captions, and choose Show Subtitles. I'm also going to put in the link for our CART if anyone would like to view it in a different screen. Also, if you're having any trouble seeing the ASL interpreters or closed captions or have any other tech issues today, please use the chat function to message all panelists and we'll be happy to assist you. Now, it's my pleasure to introduce our presenters today. We have Amy Parko, Carmen Aliber, and Anne Sheldon. Welcome.
Thank you so much, Stephanie. So I'm just gonna share my screen. Feel free to let me know if there are any technical issues and pass it off to Carmen.
Great. Thank you so much. And thank you all for being here today for this really important training and workshop. My name is Carmen Aliber, and today I join you to share my story and hopefully shatter the stereotype of what a domestic abuse survivor looks like. In 2019, I had a family, a home, a career, savings, and a very distorted definition and image of what domestic abuse looks like. I used to think it would never happen to me until it did. I quickly learned that domestic abuse does not start with bruises, blood, and breaks. Rather, that is where it usually leads when we fail to recognize the patterns of coercive control, which is the foundation of domestic abuse. Unaware of the tactics or the term coercive control, I did not know what domestic abuse looked like. I fell prey to a predator who stole my innocence. He shattered my confidence. He isolated me from my support system. And then he coerced me into applying for a marriage license just 14 hours after I received an unexpected cancer diagnosis. He told me not to tell anybody. Days later, we were married. 5 weeks into that fateful relationship, the abuse began, starting with an unimaginable control, psychological manipulation, and financial demands, including his expectation that I would be responsible for paying his son's college tuition. When all else failed, he used threats of divorce to control me. Mind you, I was at my weakest. I was dealing with a cancer diagnosis and recovering from surgery. 6 months into that marriage, COVID hit. I was quarantined with an abuser who sought to control everything from my clothes and hairstyle to the way I spoke, the time I went to bed, my diet, and my weight, or as he liked to call it, my shape. This subtle takeover, which was disguised as his desire to help me live and look better, quickly morphed into what I discovered was an insidious pattern of manipulation known as coercive control. I found myself living a nightmare behind closed doors. I was the target of his emotional, psychological, financial, technological, legal, and other forms of abuse that are still too personal and painful for me to share. So many people have asked me, why didn't you just leave him? Why didn't you just leave? It's a question many abuse survivors are asked. Some have children that make it difficult to leave. Others lack the financial resources. Some stay for religious and cultural reasons. For me, I was paralyzed. I was paralyzed and silenced by the shame and stigma of domestic abuse because I always thought it didn't and it wouldn't happen to me. I had sold my home where I lived for 30 years. I thought I had no place to go. Given my professional career, I was determined to hide the truth of what was happening so that I could protect my job and my income, which was my only source of independence. I tried to protect my children from my abuser's threats to disrupt their adult lives and careers. Acquiescing to his demands felt a whole lot safer than the threats he made against me, my loved ones, and my career. Afraid and manipulated by his control, I drained my savings to assume his mountain of debt, a form of abuse known as coerced debt. When his psychological and verbal battering became too much for me to handle, I retreated like a child in the fetal position, begging him not to hurt me. I cowered under a blanket one night, feeling the heat of his raging breath on the other side of that fabric. It is a memory I will never, ever forget. That comes second to the chill of sleeping in my car one night at a highway rest stop, a cold November night, the only place I had seeking refuge from his abuse. Behind closed doors, this cycle continued for 21 months until I finally found the courage to walk out and filed for divorce. I left him, but his abuse continued. Post-separation, my abuser continued to send me ominous messages, including a warning that he had others monitoring me on his behalf, which I've now come to know as proxy stalking. He continued to send random but chilling messages to my friends, my family, my neighbors, my colleagues, my fellow advocates, and me. The day after Christmas, he sent one that read, quote, "How long does Carmen have to live?" End quote. He refused to release me from his E-ZPass account, which allowed him to track my whereabouts and prevented the Massachusetts Department of Transportation from issuing me my own transponder. I remained under his control even when I tried to get out. More legal intervention was required to combat this pattern and his tactics to control me. A forensic investigation revealed that he had locked me out and taken sole control of my email account. Without my knowledge or consent, he had linked my devices to his, allowing him to access my emails, my phone calls, my texts, my photos, all at a time when I was trying to leave him. more legal intervention was required after discovering that he was in the final stages of refinancing our jointly owned home that I had left, but again, without my knowledge or consent. While this pattern of abuse qualified me for the state's address confidentiality program, I was told that I would likely not meet the threshold for a 209A protective order. I asked why, and I was told because you do not meet the current definition of domestic abuse. In that moment, I stood and said out loud, I am changing the law. On June 20th, 2023, I broke my silence on Beacon Hill, sharing my story as part of a legislative briefing to support the enactment of a new law to protect survivors of coercive control. Exactly 1 year to the day later, on June 20th, 2024, Governor Maura Healey signed House Bill 4744, an act to prevent abuse and exploitation, into law. Next slide, please. As a founding member of Together Rising Above Coercion, a statewide grassroots coalition of abuse survivors, advocates, and allies, I know firsthand the devastating effects that coercive control has on victims, survivors, their families, and our society at large. Today, we have the vocabulary and we have this law to protect others from coercive control, which is the foundation of domestic abuse. On behalf of survivors everywhere, I thank you for being here today to learn more about this new law and how it can protect others. Working together, we can and will help others rise above coercion. I thank you so much for being here, and I now turn it over to Amy and Ann to walk you through this law.
Thank you so much, Carmen. I think one thing that is pretty amazing about Carmen, well, first of all, thank you so much for sharing her story, but it's pretty amazing about her story and her advocacy is it's really uncommon that a law gets passed so quickly. So it's really inspiring that you shared your story and advocated for a new law that, quickly passed. Very, very uncommon, amazing work. So yeah, my name is Anne. I'm an attorney at Mass Law Reform Institute. I will just kind of go through some of the updates to the law, read the fine print, and then pass it over to Amy to go into some more examples around coercive control and what she's seeing as an attorney practicing in the courts. I'm no longer, I work at Mass Law Reform. I work in the Clavic Initiative, but I am a former family law and domestic violence practitioner. So yep, as Carmen mentioned, this law took effect on September 18th of 2024. What's worth mentioning for folks is that there are a lot of meaningful changes for survivors under this law, specifically around explicit image abuse. But today we're really just focusing on the changes to 209A, which is our restraining order law. So what I'm going to do now is just go through the actual text of the law, because I think it's helpful to really kind of read through it. So just going to read aloud. So a pattern of behavior intended to threaten, intimidate, harass, isolate, control, coerce, or compel compliance of a family or household member that causes that family or household member to reasonably fear physical harm or have a reduced sense of physical safety or autonomy. So should have mentioned, so this is adding to the definition of abuse. So I'm sure you all know about the traditional definition of abuse under 209A. This is adding to it, so it's not replacing anything. And, folks are familiar with the old definition of abuse under the restraining order law that's still in effect. You talk about imminent fear of physical harm or imminent fear of physical harm. It's worth noting here that you talk the language is different. It says a reduced sense of physical safety or autonomy. So what is a reduced sense of autonomy and how will the courts define it? That's kind of an ongoing question. I think we're going to need some case law to develop that. We look forward to hearing from you guys as you're in the courts, what you're seeing around how that reduced sense of autonomy and physical safety is used. The other thing to note is just intended. You need intent here to coerce or compel, right? You can't just, it's not the allowance that the parent gives their kid, you need the intention. So similar to folks who are familiar with 258E, it's set up in a similar way. You have a pattern of behavior or 3 specific acts. So these are types of acts defined under pattern. So the thing to note is a pattern of behavior that includes but is not limited to. So the things I'm about to read to you are great examples of things that could constitute a pattern. But should you be working with a survivor that's experiencing coercive control and it doesn't neatly fit under this list, a good reminder is that they should still bring that information forward, that the law does, this list is not limited. And then what is a pattern? Again, another thing that will have to be fully explained through case law, but we're thinking that a pattern is likely similar to 258E, 3 or more acts. I see a hand raised. I'm just going to note, sorry, we should have mentioned this in the beginning. I think we discussed doing questions and comments at the end. But Stephanie is monitoring the chat. So if you have any thoughts or concerns about that, just put a message in. So these are the types of acts that are articulated under the statute as potentially contributing to a pattern. Isolating the family or household member from friends, relatives, or other sources of support. Depriving the family or household member of basic needs. Controlling, regulating, monitoring the family or household member's activities. Communications. Oh, sorry, I have to move my Zoom screen to read it. Activities, communications, movements, finances, economic resources, or access to services, including through technological means. One thing to note is that Amy is going to go through some examples of coercive control that kind of fit under these examples in the statute in her presentation shortly. So if you have questions about any of these, hopefully it'll be addressed then. If not, we'll have questions at the end. So continuing, compelling a family or household member to abstain from or engage in a specific behavior or activity, including engaging in criminal activity. Threatening to harm a child or relative of the family or household member. Threatening to commit cruelty or abuse to an animal connected to the family or household member. Last slide on section A, I promise. Intentionally damaging property belonging to the family or household member, threatening to publish sensitive personal information related to the family or household member, including sexually explicit images, or using repeated court actions found by a court not to be warranted by existing law and good faith. So folks who are familiar, a lot of those track, right, the high-risk indicators for homicide. And also, again, the threatening to publish sensitive personal information fits into some of the other types of abuse that were addressed in the legislation. The last piece, so I'm sure Amy will touch on this, the repeated court actions found by a court not to be warranted. That could be a little tricky. We've already been hearing from folks it's been a little tricky, but a good example is if a judge put a gatekeeper on a case. That's worth bringing up. A gatekeeper is sometimes a judge could limit somebody's ability to file in a case without permission of the court. You see that sometimes when there's abusive litigation. Okay, so then this is section B. So those were, that was all a pattern. Those are some example or the examples under the statute that could fit under a pattern. So this, similar to 258E or our harassment order for folks who are familiar with that, this is section B, a single act. Okay, so I'll go through the language again and then we'll get to the single acts. So you can either have the pattern or a single act intended to threaten, intimidate, harass, isolate, control, coerce, or compel compliance of a family or household member that causes the family or household member to reasonably fear physical harm or have a reduced sense of physical safety or autonomy. So these are the acts. Oops. Harming or attempting to harm a child or a relative of a family or household member. So you only need one, right? Committing or attempting to commit abuse to an animal connected to the family or household member. Publishing or attempting to publish sexually explicit images of the family or household member. So for those of you who are like, what was she saying about 258E, this tracking it? Why was she talking about a pattern? So for those of you who are visual learners, here you go. So in essence, what this means is that this definition of this language to add to the definition of abuse under 209A, so it's in section 1DB, you either must show a pattern of coercive control or one of the specific single acts as defined by the statute. So for folks who like a visual, I hope that this is helpful. You either, the pattern is under section 1DA, and the three specific acts are under section 1DB. And so you don't need both. You don't need a pattern. If you have one of the acts under 1DB, you're good to go. Well, I mean, again, as attorneys, we tell folks to, under the old definition, under this new addition to the definition, just put in as much information as you have, certainly. But technically under the law, should you meet one of these, you're good to go. If not, you want to demonstrate a pattern. And a pattern, this isn't in writing, but we think it's similar to how 258E has been read into case law, 3 or more acts. Okay. So one thing, so now I'm going to touch on some related issues. And the thing to note is you'll hear me say a lot, like, we're not really sure what this means. We have to wait on more case law. This is a new law. And the thing about new laws is we kind of have to, wait for the courts to clarify it a little bit. But this is what we know now. The one thing that I would mention is we've heard from practitioners kind of on both sides of the bar that they're a little worried about this being used by abusive parties in order to try to obtain restraining orders against a survivor. The example of, an example of litigation abuse. So what I remind people of in those circumstances is that our restraining order law specifically addresses mutual orders. And just to remind folks that they're subject to a heightened legal standard as well as procedural requirements. The procedural requirements, you'll see them right in the statute, section 3 of the statute, is that you need written findings. They must be detailed. And then, for the lawyers or folks who like getting into the case law, I put some sites in there as well. But essentially the written findings, you can't have a check the box. You can't fill in the box for the judges. It needs to be a detailed written finding. And it needs to be specific enough to advise the police about, so the police kind of have guidance on who is actually in violation of the order. Because as you can imagine with the mutual order, violations can get complicated. And then also case law has recognized that these stringent requirements in section 3 for mutual orders reflect a legislative policy against the issue of mutual orders, except in rare circumstances, and as a safeguard against retaliatory orders. So I bring that up, when you're working with survivors, it could be as simple as like, if your abuser is also getting an order against you, make sure that you ask the judge for written findings. So yeah, just a note about mutual orders, always a good reminder, but especially in this circumstance. So the other piece to know, as I touched on this a little bit, this expands the definition of abuse under 209A. It doesn't replace the definition of abuse, it adds to it. But what this means is that if you look at the statute, it's under definitions. So it expands the standard for obtaining a restraining order, but also technically what constitutes a violation when the face of the order requires the defendant to not abuse the plaintiff. And as we'll discuss, I think, next. It also affects extension hearings because of the standard of abuse is part of the standard history of abuse. So how exactly to report a violation on coercive control? I think again, that's something that is complicated. We've had police folks that we've been working. I mean, I'm interested to hear what you guys are seeing. My boss was told that, one instance of not paying child support, according to a police chief, I believe she was speaking to, constitutes a violation. But I don't think all police officers are interpreting it that way. I think more case law. I'm saying that a lot, but more case law and training is needed in order to kind of suss that out. But at present, what you should know is that this changes the definition of abuse. So that changes how abuse is used in every aspect of the statute, including the standard for obtaining an order and what constitutes a violation. So extension hearings, yes. Okay, I thought this would be the next slide. Again, another area where it's developing. What I would remind folks is that extension hearings, as I'm sure many of you know, it's a different standard and it does not require a new incident of abuse. So this is in section 3 of the statute. This has always been the case. So what is the different standard for an extension? So, sorry, I should back up. An extension, what is an extension? So after you obtain your restraining order, after you have the ex parte order, which is the initial time you go in to get the order, and then you have the 10-day hearing. So that's the two-party hearing where the defendant may or may not be present, but certainly has notice of it. Then under law, you should have the order extended for a year. Sometimes it's less, but it should be extended for a year. And then at that year mark, you have the ability to go in and ask for an extension of the order. And so the standard at this hearing is that the order is necessary to protect the plaintiff from the likelihood of abuse. That's the standard. We had more time to go into the cases and some of the factors that we talk about. IMLA, for folks that are familiar, is a really great case to look to when you think about extension hearings. But all I wanted to point out here is that it's a different standard. It does not require a new incident of abuse. And, in fact, if no abuse has occurred during the pendency of the restraining order, that's evidence that it's working. But also that the standard is about protecting the plaintiff from the likelihood of future abuse. And so do they have a continued need for this order? Will it protect them from future abuse? And again, remember now abuse is defined to include coercive control. So, always the recommendation is to put, certainly don't only focus on coercive control. If there's all the instances of threats or physical abuse or sexual abuse, I would, if the client or if the survivor is comfortable, recommend including as much as you can. However, it is important to know that no longer is technically all that you need, or the only way to get a restraining order. Okay, so now I'm going to pass it off to Amy to go through some examples of coercive behavior.
Hi, everybody. So for what I understand, there's a lot of advocates in the audience, as well as other practitioners and survivors and some attorneys. Before we move on to some examples, I wanted to, I have this funny feeling that some of you might not know what case law is. So I just wanted to review that real quick because it's something we talk about as lawyers a lot, but I want to make sure everybody understands. So in the world of law and in restraining order law specifically, we've got some things that are based on the law or a statute, and that's kind of what we're talking about in detail today. But case law is when certain circumstances and cases come about where the law is tested. So let's say, somebody goes to get a restraining order and they don't get it, and they should have gotten it based on the law or the statute. Some brilliant attorney will take that case to an appeal, and ideally the case will then be published as an opinion, and that creates case law. And what that case law does is it sort of fills in the blanks in the statute so that lawyers will know, how the court should be handling an issue that wasn't quite contemplated in the statute. So that's what case law is. Another thing that occurred to me while we were talking is that there's so many exciting things this statute improves on and changes, but there's some things that we're still like limited with. And a lot of what I want to talk about as we get into the examples is still limited by some of the things that are just human behavior. Judges have discretion. So no matter what, they're always going to be deciding who to believe. And whether the person who is telling their story, whether that is the plaintiff, the survivor, or the person who's defending themselves against the restraining order, is that they've got to seem believable. Now, because the world is a biased place, and because domestic violence is such a difficult thing to sort of define outside of these kinds of trainings and in society, you still are dealing with bias. And as much as the judges try hard to remain neutral, they still are affected by their internal bias. So what that means is sometimes, no matter what you're doing, you have to think about the judges as humans, even though hopefully they've had some great training. And so a lot of what we're going to talk about today has a variable effect based on who your judge is. So, as attorneys, what we'll frequently do is try to figure out what judge is hearing our restraining order, and then we'll ask around our colleagues, hey, have you ever done a restraining order in front of Judge Sheldon? How is she? Does she understand domestic violence? So that's something that we're doing behind the scenes. But now, as an advocate especially, I just want you all to know how much your work is valued to attorneys out there that are doing this, because frequently we will get involved at the 10-day hearing, but we don't always have an opportunity to consult with a client before they go in for their ex parte hearing, which is that first time they go into the court with their complaint all filled out. So sometimes we're really hoping that either the client has done a little research on their own, or that, God willing, they're working with an advocate that can help advise them. And so I hope one thing you take out of this today is an ability to sort of help the client on the front end before an attorney gets involved, so that we can sort of work together, even though we'll likely never meet, in order to help the client out and make the whole experience more successful, but also less stressful. So we're going to go through some of these examples. And for a lot of you, this is probably review, because those of us that have worked with survivors know that abuse is so much more expansive than the old definition of domestic violence. And I'm a survivor of domestic violence as well. I also worked for Casa Mirna, the domestic violence agency, for 5 years. So many of us out here doing this work have that kind of background experience. So I just want you all to know that we are always really grateful for the help you can give. And if clients tell you we don't call them back, just a fun side note, we take very careful care to make sure nobody falls through the cracks. And there's always a lot of miscommunication about who survivors have reached out to and how they've been able to get in touch. Never hesitate to reach out directly to the organization or an attorney if you feel as if your client isn't being sort of given the kind of help that you would hope they'd get from one of these organizations. Okay, so moving on. So some of the examples of coercive control that we like to highlight in order to sort of bring this into the case and show it to the judge are these are great examples, but it's important to remember that you know more already than what's in here. I'm sure you could come up with 100 other examples you've seen and what you observe. But some of these are really helpful guidelines, because you can look over them and really be creative about how you can sort of compare what your example is to what's in these examples. So acts of isolation is a great one, because you can isolate somebody in a lot of different ways, but they give you some good examples, like hiding keys and just generally alienating the survivor from their support system. But you can do that in lots of different ways, right? You can keep them from being able to pay their bills, take care of their job. There can be monitoring, and then of course financial abuse. The one sort of like sticky part of the statute that a lot of attorneys are kind of curious about and a little nervous about is the part about restricting autonomy. So we're going to go through some hypotheticals at the end of my part and sort of talk about how we can sort of show these things that are sort of these beautiful words in practice. And then some of them overlap too, right? Like psychological can be a real combination between lots of things. A lot of our survivors now are becoming educated on social media. And so, using words like gaslighting a lot, and sometimes they'll be using it correctly. Other times they've heard it and they think that's what it is. So it's always good to follow up and get a little more detail about what they consider to be that kind of abuse. And then we've got sexual or reproductive abuse, which I'm sure many of you have run into. It's one of the ones I think is, common and awful in family law cases. And then intimidation and threats. Of course, if it's a threat to harm, we fall into the old statute. But some of the threats that I know for me, my clients are always like, he threatens me all the time. And in the past, I'd be like, does he threaten to hurt you? And they'll say, no, typically the threats are to take the children away or to take advantage of my client's immigration status. So one of the great things about the new statute is it includes some more of that. And then as Anne had mentioned, the legal abusive process. That's one that I've run into that's a little bit more challenging because so much of the litigation abuse can be explained away pretty easily as a necessary tool that, the abuser needs to use. Like, for example, she's taken my kids away. I have to file this motion to get my parenting time back. And maybe that's true, but maybe what's also true is that he has done something to cause this to happen, or she. All right, next slide. So the new paperwork is incredible. If you haven't had an opportunity to check it out, click on the link later when you're reviewing your slides. But the new forms have like a checklist that is so beautifully user-friendly. I've seen a lot of these come into the office when the clients have gone in on their own, and I think the clients are so much better able to explain their abuse with the designations and the different checkboxes. But I recommend you familiarize yourself with them so that as you're, helping a client with what they need to talk about when they go to court, you can kind of follow along in the form, or you can fill out the forms ahead of time before the client even goes to the court so that you can work on it together. All right. So as we started to talk about, some things have changed, but most do remain the same. So you really need to, still keep in mind that the old part of the statute is still very much in place. This isn't taking away anything, it's just adding more towards it. And we're going to go over a few of these when we do the hypothetical, so I don't want to spoil all the fun. But some of the things that haven't changed are the requirements around it being a household family member, substantial dating relationship, the kinds of relief that are available. Again, the statute says what it says. What happens in practice might be a little bit different, and that's something that we as lawyers really struggle with, especially when we want to explain it to our clients or to the advocates we work with. And then, of course, there's no changes to the consequences of a violation, as all you likely know that, it's a civil order, but if it is violated, it does become a criminal action, which has huge consequences for the litigants. And then lastly, it doesn't change the rules of evidence. And as attorneys know, but advocates might not, the rules of evidence are a little bit lessened at restraining order hearings as compared to formal court proceedings at like a formal trial, which is really helpful for our clients because things like hearsay are allowed in a restraining order hearing. If you've got like a document or a screenshot of a text message, it's just, a lot easier to get that entered in as exhibits. Now the judge still has that discretion where they can say whether they find this document reliable or not. But the law and the case law, actually, this is a good example of case law, is that they're still supposed to liberally let in evidence. Okay, next slide. So one of the things I've been really curious about and experimenting a little bit with is, in the restraining order law, it's law. It is what's, supposed to be done. And if the courts aren't doing it, you appeal. But in other areas of law, you can use this definition in a persuasive manner. So that doesn't mean that you can convince a judge and, change the law, but it does mean that judges are becoming more familiar with this terminology, and you never know, in the future it might be sort of baked into some other statutes. So let's see. Just want to make sure I got everything in this slide. So the impact on child custody is the part that I get the most excited about, because a big part of my practice is in the family court. So I do things like custody cases and divorces and, things involving custody and child support and everything you can imagine in that realm. And so where I've been using this persuasively is in my custody cases, because whether there is domestic violence has a huge impact on legal and physical custody. So what I've been doing in a lot of my pretrial memos or in my motions is describing the abuse and then defining it as coercive control, because I think it helps bring more legitimacy to the arguments I'm making that are describing these behaviors that on their own might not seem that concerning, but when you can illustrate them in in this pattern or in context of the family, I think it can be incredibly helpful and persuasive. So yeah, I've also been bringing it up more in my oral arguments as well. So, for other attorneys that are in there out in the training, I encourage you to sort of experiment with that a little, because again, I just really think it helps educate the judiciary on abuse as much as possible in every corner of the courtrooms. Okay, next slide. So this is where we talk about what's working and what isn't working. And honestly, it's for the most part, it's too early to say. I've done a number of restraining orders, but I find typically I'm doing a lot more extensions. And most of my extensions were based on physical violence. So I haven't had as many opportunities to go in yet on straight coercive control. So I've been talking to a lot of my colleagues. There's quite a few of us here at Greater Boston Legal Services that do restraining orders, as well as a lot of listservs and such that we chat on. So some of the things we've seen early on are that, judges are human, their bias is real. They may or may not have read about the statute. Sometimes they'll take a brief recess. I've had that happen, and then they'll go read it and come back, which is pretty cool. But again, they're human, so maybe they're not necessarily buying your argument, and they go back and read the statute to try to figure out a way to not grant the restraining order. But that's always happened, and I don't think that will change with this new addition, hopefully. Another thing I've noticed is that there are some judges out there that are familiar with the new law, and they're quite comfortable like reading it out loud and the new definition. I think in the district courts, I've seen a little more continuity and education of the judges. I've seen, a few family law judges that we kind of have on our radar as being a little more, what's the word for it? Challenging when it comes to, being re-educated about domestic violence. That can come as a challenge. We have seen a couple of mutual orders in our office, and that seems like a step in the wrong direction, because that was something I had kind of seen a lot less of over the past 5 years. But I think that certain judges, there's one in Suffolk I'm thinking of specifically, think that, well, this opens it up so that, she's abusing him too. So like in a custody situation, it might be that she's withholding the children because of his abuse, but that might get flipped on its head, and it might seem like the mother is withholding the children, which is creating justified frustration for the father. So, we are kind of aware of that challenge, and we're always thinking about, how we can think smartly about that going forward. And for attorneys, especially attorneys that do appellate work, we want to be really careful about challenging cases and bringing it to appeal, and the idea that we could create this case law that might not be favorable to our survivors. So it's a very complex and ongoing discussion. But if you do have a client that has, not been granted a restraining order that you feel really fits within the statute, there is always room for advocacy on the appellate level, which means basically just, filing an appeal. One of the challenges is litigation abuse. So, there are so many justifiable ways to file litigation. So I'm finding that many judges really refuse to see litigation abuse. And it's not easy to get a gatekeeper motion. Anne mentioned that term. That's usually what happens when you've got a case where somebody's filing like too many things. So you're ending up in court too frequently. But in family court, we have a certain judge who will make this gatekeeper motion for both parties, even though one has filed 9 motions in the past year and the other's only filed 1. So again, this is more of a concern about, judges in general versus that new coercive control definition. The other thing I think is a little bit challenging is that coercive control takes a little bit more nuance to explain. So that means that you sometimes need more of a timeline, or you might need a little more of a longer narrative. You might need to go back in history a little bit more in order for the story to make sense. Because if you start out with what brought them to court that day, it might not make sense in the context. So I've got some practical tips. We can do some practical tips and some ideas I've come up with to help make it a little bit easier, and where the advocates can really come in here to help is that you can help them when they write their affidavit. So before they go into court for that first order, they have to write down why they need this protection. And so if you can help them organize their thoughts, that can be so helpful, because as many of you have experienced, survivors have a difficult time with time frames, with timelines, with trying to figure out, I know that happened last year, but I can't remember when. And if they get up in front of a judge without having a clear idea of when the things happened, they're not going to sound as believable. And so a way that you can really help them out is to get a timeline put together. And sometimes a timeline is good enough just to refresh their memory, but other times you can make a demonstrative chart for the court that you could share with the court. And the lawyers, we call this a chalk, but it could be anything that you could create that you could share with the court, because remember, you're allowed to submit evidence. You can help the client also make an outline. As Anne mentioned, you want to remind the survivor to ask for written findings if they do a mutual order. And then another tip that I got from one of my colleagues here is to pull out the old power control wheel when you do your, sit down consultation or prep session with your client, and have them highlight everything that happened in their relationship. And that can really help you find the facts that support the theory you're developing with your client on how to present this case. Okay, I'd like to move on to some examples, because this is where it gets really fun, but I also want to be aware of the timing. So Anne, if I get a little long, we don't have to go through all of them. Let me know so we have enough time to take questions at the end. Okay, so I took some fun facts from cases we've had in our office and cases I've seen in my career over the past 10 years. So some of these, I used all the names of my aunts and sisters and sister-in-laws too, just to keep it fun. So the first one I want to talk about is Mary. So Mary's partner keeps throwing her birth control out, which results in her missing pills until she can get to the convenience store or the pharmacy to get a replacement prescription. When she asks her partner about it, he denies her, he gaslights her, and he's just like, oh, you're so forgetful. This is so you can't keep track of anything. This eventually leads to an unplanned pregnancy. So first question is this a good situation for a restraining order? First, we look at the relationship, right? This is her partner. It looks like they've got a long-term relationship. So we've got that checked off. But is this abuse? Is this abuse under the coercive control statute? And I think you could argue yes. Part of restricting somebody's autonomy is, causing an unplanned pregnancy. So this is going to take some nuance to talk about, and it's also going to be something that you need to kind of make sure your client is prepared to talk about. And so what I'd like to kind of go through is some ideas for what I would be looking for evidence if I were hired to take this case, so that you as advocates or as attorneys or as survivors can make sure that you're as well prepared as possible for the hearing. So some of the ideas I had for this were she could get her prescription records from her doctor, and that could indicate that she has had to get replacement prescriptions. And ideally, we would want to see this happen a few times rather than once to create this sort of pattern. Let's say the unplanned pregnancy happens and she decides to terminate the pregnancy. Any evidence that she needed to do that might be helpful. Medical bills for whatever wasn't covered by health insurance. That, remember, under the statute, you are allowed to ask for some retribution or some money back for things that the abuse caused. So let's say your health insurance didn't cover that and you had to pay for it. You can ask for that at the restraining order. We talked a little bit about the affidavit. That's such an important piece of writing, because if you do a good job on the affidavit, then the client will not have to testify as long or as in detail, and the judge can refer back to that as sort of a good place to get their organization and timeline. And don't forget too that the testimony of the client, of Mary in this case, that is evidence. The words she puts out are evidence, and then the judge just has to decide if he believes it or not, or if she believes it or not. Maybe there's text messages between the parties about the missing pills. That could be helpful. Maybe Mary finds the discarded half-used pill container in the garbage she's taking out to the curb on Monday morning. That might be a photograph she could take. Could you poke holes in some of this evidence? Maybe, but some of it will help corroborate the story. It'll make the client seem well prepared and more credible, ideally. Okay, the next one is Jean. So Jean's husband punishes her for talking back. And the way he punishes her is by leaving her home with their 3 kids for the whole weekend, 3 days at a time. Now, Jean has no car, no car seats, no stroller, and her husband took her driver's license with him because she is an undocumented immigrant, and he uses this driver's license theft to, coerce her into doing what he wants. So what is the best plan for showing this? Now, this is where a timeline would become very effective, because you want to show that he has demonstrated a pattern. And there's so many examples in this hypothetical. I wish we could kind of go back and talk about them together. But if you look through all of the examples, you'll see that this one really ticks a lot of boxes. So you could talk about a lot of different things, like providing for her necessities, isolating her. So how can we plan it? Did she call the police? Was there a police report filed? When she couldn't, get what she needed to take care of the kids over the weekend and do what she needed to do, did she get help from somebody else, a friend? Is it possible that person could come and testify to what they had to do in order to help them? Next one is Maria. So Maria's ex-boyfriend came to her bedroom window of her apartment in the middle of the night and was asking her for sex. He was a little bit drunk. A few nights later, she hears someone knock again, but she looks at the window and there's nobody there. A week later, her air conditioner is pushed through the same window and it falls onto the floor or under a bed, and she calls the police. Because the boyfriend did it the first time, she feels certain it's the boyfriend that's done it the other times, but she doesn't have any proof. She didn't see him, and she, may have filed a police report, but all the police report says is that, she called the police because this incident happened. So how can Maria present a really good case at court? So she could bring in the police report to show that, this happened. Ideally, every time it happened, if she had police reports for all those 3, that's great, because it can show, what she told the police officer when it happened, why she was scared, and that it was serious enough so she contemplated it. But also, it helps to refute the idea that she's fabricating this for an unfair motive, because like these incidents happened, it's not like she just popped into court. Again, if she had any pictures of the air conditioning unit as it came into the house, that could be helpful. If there's any text messages that, of him asking for, to get together for sex, that would be helpful. But the bigger part here is about the pattern, really getting into the pattern. So I would want to be like, this date, this date, this date. Or maybe you could say like how I was like a few days later, then a week later. Like there's some ways to convey the information that's in a way that really helps explain why it was so scary to this person. All right, next one is Tia. So Tia had consensual sex with a person she met at the party. She didn't know it, but this person filmed the encounter and then sent it to a group chat. And she found out because a mutual friend of hers was on the group chat. So this one brings into sort of purview a lot of the different things that come up in the new statute. But before you get too carried away, we have a problem. This is somebody she had consensual sex with one time at a party, and this might not qualify as a substantive dating relationship that would qualify for a restraining order. So this might be something where you have to really think ahead. Like you might get excited because you heard, oh, there's some revenge porn in there. We've got this new statute that deals with this. Let's go. But we might need to fight about the relationship first. And maybe that means that you've got to pull out more facts from the client. Maybe they hooked up a different time, a different, if you can try to prove that it was more of a relationship, maybe you can. If not, you might have to come up with a different solution. That might mean that you, contemplate filing criminal charges. That might mean that you look to using, instead of an abuse prevention order, you might have to use a harassment prevention order. So there's other things you can do. Another thing to think about in these situations are the ages of the litigants, because you might run into a situation where you might have some underage people, in which case, you might be reporting a crime. So let's say you've got a litigant that's under 16 and she comes to you expressing this, I was at a party story. You want to make sure that there's some different criminal consequences for all involved. All right, just two more. Rebecca's ex-husband has filed multiple 51As to DCF, police reports, criminal complaints, his own abuse prevention order, as well as a modification of their divorce agreement. Rebecca's recently begun dating someone new, and she believes that this is retaliation because he's still jealous. So this is an example of litigation abuse. And this is something that we see a lot in the family law court system. But again, it's hard to prove because it's so frequent. These abusers are working now with 5 different systems that don't talk to each other. And so, DCF is like, oh gosh, we've got this standard where we have to really be careful because children could be abused. And so they're doing this very thorough investigation. They don't know at the same time this person's doing it in all the other places. So what we really need to help our client with here, and this is where an advocate can come in really handy, is we need to collect all that evidence. So we need to get some documents from DCF. We need to get the clerk's hearing complaints, the criminal complaints. We need to get it all together to present to the restraining order judge so that we can really show examples of how this is happening. And this is, again, a place where a good timeline or an outline can help, because you can put it all together in a document. All right.
Right,
Last one.
looking at time, I'm wondering if I see a lot of questions in the chat. I'm wondering if we want to skip the last one. And
excellent. We could skip that last one. I just want to point out that I did do one with a male survivor just to keep it fair. Thank you, Anne.
Yeah, sorry. Carmen, you're up. You're muted.
Thank you so much, Amy and Ann, for providing this important overview, and for everybody for attending. As we wind down today's session, I just want to offer a huge shout out to TRACK, Together Rising Above Coercion. Again, it's a statewide grassroots coalition committed to protecting survivors of domestic abuse. And while it was my story that you heard today as a member of TRACK, I can assure you that my voice and my story is just one of thousands throughout the Commonwealth. So we are grateful to each of you on the front lines who are helping those of us who have broken our silence and come out from behind closed doors to continue making a difference to help others. As grateful as we are to have the coercive control legislation in place, we also know that success does not end when a law passes. And we rely on agencies such as MOVA, Greater Boston Legal Services, Mass Law Reform Institute, as a source of information, training, and support for those of you who are representing and advocating for survivors. So as disheartening as it may be, and I've seen a couple of comments in the chat that we still have work to do, I will say the good news is that we have opened the door to a new chapter. Progress is being made. Not a week goes by where we don't hear of survivors finding success for obtaining protective orders. And in 2023, I was told that it can take 10 to 20 years to pass a law like this. Working together, we, you, all of those around us in this grassroots initiative prove differently. So next slide, please. As you can see, this is a quote from Haya Barat. She is a clinical or associate clinical professor at Northeastern University's Domestic Violence Institute. She sent this to us a few weeks ago saying, my students just argued their first 209A, which was entirely based on coercive control, and it was granted. Our client had been told by previous judges that what she described was not domestic violence. And so this was the first time she actually felt heard. We are so grateful for all you did to make this very needed change to our legislation. So again, please keep up the great work. We know the stats. We know that coercive control is the foundation of domestic abuse. 97% of domestic abuse victims report experience harassment, monitoring, and threats by the abusers through technology. Of the women seeking assistance for abuse, 60 to 80% have experienced coercive control. So we know that this is the gateway to the more dangerous. Coercive control significantly increases the risk of an abuser killing his or her victim when they leave. Up to 90%, data shows, up to 90% of female coercive control victims experience post-separation abuse. So on behalf of survivors everywhere, I thank you for joining us today. Wanted to learn more about this expanded law, how it can protect others. And again, I will continue to say, working together, we can and we will help others rise above coercion. Thank you.
So I see a lot of questions in the chat. So I think, Carmen, Amy, and I will just go through the questions. Is that, Stephanie, correct me if there's another way we should be approaching that. But I see the first, oh, go ahead, Stephanie.
Go ahead. No, that is perfect. We do have a couple of questions, so if you feel comfortable going through them, please.
Yeah, absolutely. And it's actually, I'm really grateful because if it's okay with Amy and Carmen, I'll take the first one because it addresses something I meant to talk about. So this question is, I'm not sure, can everyone see the chat? Whatever, I'll read it. Do you have suggestions for how to describe DARVO tactics? And I'm gonna stop share. Deny, attack, reverse, victim, and offender, which are frequently used in courts and other venues to blame and discredit survivors. I've worked with some survivors whose abusers have accused them of such egregious abuse that the accusations bias the judge and the survivors are not believed. So I think this touches on what we were talking about earlier about mutual orders and some concerns that with the new definition of abuse under 209A that we might see as litigation tactics, abusers trying to get restraining orders against survivors. So the one thing that, it's not a panacea, certainly, and as Amy said a lot, there are things, it's all based on kind of like the court's perspective and how the evidence is presented that day. But one thing that I think is really exciting about this law that we haven't had the opportunity to touch on is that it's so detailed that it really provides the judges with almost like a good training or a good reminder about what coercive control is. So I think previously doing this work, trying to demonstrate that my client is a survivor without kind of the context of power and control and focusing on specific instances instances, I think didn't really paint the picture of really what it is to experience domestic violence, what power and control is about. And I think that hopefully the law will also help educate the bench around power control and help them have a better understanding and better ability to suss out the difference between, you know, an abuser using litigation abuse and a survivor. All right. Okay, so the next question I'm happy to answer unless you want to, Amy or Carmen.
Are you moving on to two separate clients or the specific act one?
The specific act.
I can answer this one, but it's a tough one. Whenever you have a restraining order that involves children, it's always a little dicey, because if you're in district court, they'll say, why isn't this in family court? Why did you come here? And we all know you can go to both or either. You don't necessarily have to do one or the other, but there is this preconception by a lot of judges that if you're not in family court, you're sort of forum shopping and looking for, you know, you're doing it for disingenuous reasons. And then in the family court, of course, they are more likely to be experts in, you know, child abuse and neglect, and they might be looking for something more concrete that has resulted in DCF being contacted rather than following the sort of statute as well. So I think this could be like a difficult way to get a restraining order, and I'm concerned about this one being as effective. I think that if this is the best you've got for evidence to get a restraining order, you'll have to do all those other things we talked about really well and really carefully. And when you have a case that's that complicated, that might be a case where you really reach out to legal services so that the client can work with an attorney, because that more nuanced way of handling the law might be necessary.
Sorry.
Can I jump
Yeah,
in here
I
and just
just
add?
jump. Oh, sorry. Go ahead, Carmen.
No, I was just going to say, if I can just jump in and add that many, and it's related more to the adults who are seeking these orders. Amy, you brought up that you can apply through both the family courts as well as the district courts. I am hearing that those who are having the most success are applying through the district courts, because then they can also follow through. If somebody violates the restraining order, it's easier for law enforcement to follow through versus bumping you back to family court to address it.
And thanks, Carmen. The thing I was going to add is that, so I think that question about a specific single act of harming or attempting to harm a child, you know, under Section B of the language, whether or not that harm could be coercive control. And I would say I agree with Amy that again, this is kind of something we'll find out as case law is developed, but I think that the harm of the child or the relative of the family member, I think would fall under our traditional definition of harm, like a physical harm, or attempting to harm, or if threat or an action attempting to harm. And I think this addresses the gap of, you know, your child is physically harmed by your abuser, but you're not, and then you may not have standard for a restraining order or basis for a restraining order under the old definition. And I know this certainly came up a lot when I was doing this work. And so I think that that's more the gap that it's seeking to address. But as we've been saying, a lot of this is an open question, so we'll see. So then the next question is, I've been told recently, by two separate clients that they were denied 209As multiple times in the last 6 months or so. In one case, the court denied the order request that because the plaintiff hadn't been physically assaulted her. In the second case, the court denied multiple requests for 209A despite the victim having been brutally assaulted, and subsequent threats and intimidation, saying the plaintiff didn't have enough evidence. So this is an example where we put our information in the chat, reach out to us. First one, I'm not sure the facts of the case, but maybe, you know, coercive control didn't take effect until September. The judges were still learning about it. Maybe it would have fit under coercive control. And the second case, you know, not knowing all the specifics, I certainly think consulting with an attorney giving us a call to talk through it, possible appeal, is something certainly worth considering.
And I just want to add that clients can request a copy of the recording themselves so that they can listen to it and see if they can get some clarity. Blank. So like I've been trying to kind of bring out more facts about what that fear physically looks like, in addition to like, you know, all the other stuff I've been throwing at the wall.
Carmen, I'm wondering if working with track, this is something that the members talk about. But this next question is, can you speak to how abusers use systems such as protective service agencies, child protection, adult protection services, reporting to assert power and control over their victims? They asked about the best way to.
So I think we see this a lot. A lot of the people who are dealing with coercive control, these manipulators, I call them master manipulators, because they know how to manipulate the system. You know, we could have a standalone session just about the different ways that they do it. The important thing I think from this takeaway is for listeners and attendees here to understand the steps, take that coercive control wheel, identify what coercive control is, and be prepared. The Darbo question that Dr. Elliman had asked at the top of the Q&As here is a really important one. And I can tell you that my abuser flipped the Darbo thing on me. He started accusing me of Darbo, and I didn't even know what Darbo was. And he handed me this, you know, printout that he had done from the computer. And I was so confused what he was talking about. He was actually doing it to me, but he was flipping the script. And I think that if people understand that when these coercive controllers go into court before a judge, before their attorneys, they are flipping the script. And so we need to be prepared for understanding what coercive control is. Attorneys need to understand, the advocates need to understand, and don't bite the hook. I keep telling people, don't bite the hook, understand what it is, and don't engage in it. So one of the questions that I'm seeing coming up in a few different forms is understanding under what relationship or what types of relationship does this law apply? You know, somebody has asked about tenants, employers, past boyfriends, girlfriends, spouses. At what point does it apply, and at what point does it stop? So, you know, use me if you want as an example. I'm now divorced from my abuser. Am I still covered? Would I have been covered when I left him? Certainly I would have been covered living with him, but I think it's important to clarify who is covered under this law.
Sure. Great question. I'm happy to address that. So yeah, it's a little confusing because under 209A, it's still family or household member that is covered by this law. But under that includes people in a substantial dating relationship where your family member is defined broadly as to include ex-partners or ex-mother-in-law, ex-brother-in-law, whomever. Does that make sense? Amy, do you have anything to add to that?
I think the substantive dating relationship gets a little bit more confusing, but what that generally means, that's why I did that one hypo on it, is because a hookup isn't a substantive dating relationship. It would have to be like somebody that you dated more seriously. And the case law on this is a story about like an online relationship. And they did find that because they had been together and communicated regularly during that 3-month period, even though they had never been together in person, that still was enough to constitute a substantive dating relationship. Yeah.
And a roommate. So it's family or household member. So a roommate would fit under that.
Yeah.
Okay. I see one. Can you explain the difference between no contact stay away orders and RO other than the obvious? And are these changes also applicable to the no contact stay away orders? So to answer the second question, no, these changes are not applicable to the no contact stay away order. These changes only amend 209A. There is like a slight asterisk I'll put on that could affect our bail laws a little bit. But I'm not a criminal attorney, so I'm not going to go on too much into that. Happy to provide more information. You can email me if you have questions about that. But for the most part, no. So the difference between a no contact and stay away order and a restraining order is a civil tool where the parties are the plaintiff versus the defendant. So the survivor versus the abuser in most cases, unless the retaliatory restraining orders we're talking about, and that order belongs to the plaintiff and it's their protection as outlined in the order. A no contact stay away order is part of a criminal case. So the thing that I always tell, or used to always tell clients when they would say, well, I don't need a restraining order, I have a no contact stay away order, is that, well, actually, when the criminal case goes away, so does that no contact stay away order. So the restraining order could be extended beyond the criminal case to provide more protection, longer protection. All right. Would you suggest that survivors applying for ROs write their affidavits, at least in part, categorizing their experiences based on different forms of coercive control and using coercive control technology? Absolutely. Yeah. In light of the new law, anything that fits in your experience that fits under the definition of abuse should certainly be included, whatever the client is comfortable disclosing.
Yeah, do you mind if I jump in on that one?
Mm-hmm.
One thing I caution folks about is that you also still want to think about brevity. You don't want your affidavits to be too long because judges have such limited time that they won't read more than a couple pages. So although we want things to be detailed and have good timelines, it's also important not to make it too long and detailed. The other thing I've noticed in my practice, and this might be kind of controversial, but let me know what you guys think. If you tell every single like horribly violent thing that's happened, sometimes it just sounds so terrible that it's not that believable. So sometimes when I'm trying to figure out how to present my case, I might have to pull out a few of my worst stories in order for it to sound more believable so that the judge will, actually grant the order. So less sometimes is more if it means giving the judge less to read and also making it seem more believable to somebody who isn't ensconced in the world of domestic violence.
So I think we'll just try to get through these. We have 10 more questions and 10 more minutes. So we'll try to go through them really quick. Can you file, but we'll do our best. We might not get to your question, but you have our contact information at the end of the slides. So, and we can put it in the chat too. So just quickly, can you file litigation on initial 209A in district court and probate and family court? Yes. And in most cases, superior court as well. The next question. I've been quite concerned about the format of the new 209A form because it does not include a single definition of coercive control nor examples from the law. However, the checklist includes mostly forms of physical and sexual abuse, etc. It only refers to the 209A amendment, which places the onus on the survivor to do the research to find out what coercive control is. Well, they're possibly when they're overwhelmed and scared and are in the courthouse ready to apply for the order. It's a barrier for the survivor being able to draw upon coercive control definition while writing their affidavit and preparing for the ex parte hearing. I agree. I don't know if you have anything to add, or Carmen, you have anything to add. I think it's all the more example of why safe plan advocates and other advocates in the courthouses are so valuable and important. When do you expect the new orders to be available? Good question. Hopefully soon. I think it's like some tech issue that they have to be consistent with other state orders, an order for the restraining order registry that the police use, something along those lines. So I think it's a tech issue, but hopefully soon. Okay, so the next, somebody asked about the relationships that fall under DV laws. Hopefully we answered that question already. Ways to tell the story besides strict chronological, which can be repetitive and unusual, unpersuasive. Group by types of control and relate incident to the effect on the victim's behavior. So I guess, what about visual representation? A document containing screenshots, typically grouped. Judge may not be persuaded or tune out the details of single incidents, but when they're presented together as set evidence, saying coercive behavior pattern is visually evidence. So sorry to summarize, but I think what this person is asking is essentially, is there a way to do it aside from chronologically? Should you, what if you group it under the types of behavior in order to demonstrate the pattern? Amy, you want to take that one?
Yeah, sure. I love this question because I love the idea that you're thinking outside of chronological, because you're right, there's lots of ways to present information. And as long as you kind of keep it not too long, I think that is awesome. Like I have a pattern I try to follow, which is like relationship, worst case of violence, or under the old statute, most recent, what did they come into court with? And then I would kind of get into the nuance in the relationship and the coercive control. So that's kind of my go-to, but I love the idea of grouping it chronologically. I just worry about if you could do it short enough, because I really love to keep it under 2 pages.
Okay. So this person asks, if someone has a 209A issued for physical abuse under the previous law, would they need a second 209A to enjoin the coercive controlling behaviors? Could they instead apply to modify the existing order? I'm so glad you asked this question. No, you don't need to modify the existing order. Again, the new law, I mean, I guess this is, I get so much of this kind of, we'll know more next year, but and in the future, but the new law expands the definition of abuse. It doesn't mean that if somebody's experienced coercive control that they have to apply for a new restraining order. The restraining order that your folks have in place is still in place. They could still apply for an extension. They don't need to file anything new or modify their order. In fact, we'd encourage anyone considering modifying their order to reach out to an attorney because, that could often backfire for reasons we can get into, but there are 5 minutes left. So want to try to get through as many questions as we can. Okay. As somebody sharing, I had a 209A that was not extended. My hearing, I couldn't find a lawyer till the very last minute, but the judge said I did it in good faith and did not vacate it or ask me to pay my ex-lawyer's fees, which they had asked for. Can what the judge said be used in later cases, or does that not matter in subsequent cases? I think is the question about the judge saying the restraining order was used in good faith. Can that be used to show that you're not engaging in litigation or abuse or frivolous litigation? I think that's what it might be asking. I don't know, Amy, if you have thoughts on that.
I'm a little confused by this question, but I'm wondering if this person has something going on in a district court with a restraining order and maybe like a family law case. So I wonder if they're asking if those two things can play together. In which case I would say absolutely. Anything that's said under oath in a court hearing can be used in a family court hearing. So it is important that, for me as a family law divorce attorney and custody lawyer, I'm always really concerned that my client says the same things consistently, because otherwise you could get into trouble down the line if you go to trial and you have inconsistent statements. So you do want the story to stay the same between what's going on in the restraining order and what could be going on in the family court.
Following up with a question about the extension after the amendment passed, can the survivor submit a new affidavit describing the coercive controlling behavior that happened before the law passed? Oh, okay, great question. So I'm not gonna have a great answer. Amy, feel free to chime in, or Carmen. But I think what's important to highlight here is that I believe it's IMLA, it might be Frazato. Our cases say that you don't have to relitigate the underlying basis for the restraining order at an extension hearing. So, a survivor who's seeking extension of the order, the abuser can't come in and then try to refute everything that he or she said or they said at the previous hearing. So I think, again, it's kind of an open question because we need to see how the law develops, but I think how you would want to use the coercive controlling behavior is to show is to talk about the protection from abuse, protection from future abuse that the order would provide. So again, the standard is under Frazato, must show that the extension order is necessary to protect the plaintiff from the likelihood of abuse. So now we have a broader definition of abuse. So I would say include some of the coercive controlling behavior, certainly if it's been going on since the order has been in place. But you can't really kind of go back and relitigate the basis for the order.
I will say that at every extension hearing I'll submit a new supplemental affidavit that just brings the judge up to date on what happened over the past year since we were last in court. And in that supplemental affidavit would be where I would put all this stuff that's happened that's coercive control, but maybe wasn't necessarily physical abuse. So that I would be, and I might even try to say, sure, he hasn't violated the order exactly, but maybe he's engaged in behavior that pushes boundaries, for example, and then get into the coercive control. Or maybe it is a violation now, but there's a good reason why it didn't make sense to notify the police and follow up with that.
Yeah, and fun fact from what Amy said is that's a great practice, and also the guidelines say that you should submit an affidavit of continued need or explaining your continued need for the order. So not done a lot, but a really good practice. All right, I see we're at time. We do have 2 more questions. How do you want us to handle that, Stephanie?
You can go ahead and answer the last 2. That would be great.
Okay, I'll go quick. Our strongest evidence against a defendant was his actions towards my client's cat before the new law went into effect. Can we use it? You want to take that one, Amy or Carmen?
I would say that if that is certainly an example of coercive control, if you could also use that as the pattern, what followed. If that is the one and only instance, however, based on what was presented earlier, that would fall under Amy, would that fall under one of the examples? You need to have one incident,
Yep.
Yeah, it's under section B.
Mm-hmm.
right? So the short answer is yes.
If a judge decides not to extend an order and the victim wants to appeal or apply for a new order without a new incident, is it better to just reapply or file a motion to reconsider?
Want me to take this one?
Yeah,
Okay.
you want me to take it too?
So you have a lot of options, but one thing that you really aren't supposed to do is just go in and do what we call like forum shopping or judge shopping. So you can't go back into a different court and ask for a different result. That's not allowed. You would need a new incident in order to be able to go back into court. So your option then is to file either, I think your only option really is an appeal. I don't think you can do a motion for reconsideration because it goes to judgment, which means there's no longer a case that exists. So I think your only option would be appeal. Does that sound right to you, Anne?
I'm not on the motion to reconsider. I'm not sure. Maybe.
Okay.
We could get back to you on that. I think
Yeah.
the other thing about the motion to reconsider, even if you could do it, is it would go back before the same judge.
Yeah.
So, but an appeal, again, I would advise, I agree with Amy that appeal is certainly the better choice, but something you would want to consult with a lawyer about. So give us a call.
Yeah, and we don't do a ton of appeals, and the analysis on whether a case is ripe for an appeal is really complicated and nuanced. And it's not just that the judge got it wrong. The other thing to think about is that if the judge says anything about credibility during the hearing, when an extension is not granted or when a restraining order is not granted, you're never going to be able to win on an appeal. So that might be a situation where you want to get the recording so that you can see exactly why the judge said no, because if it's about credibility, it's not going to be worth it. And it's better for your client to have a reduced expectation early on so that they don't think it's hard. So I don't want them to have a false sense of what can be accomplished through an appeal.
And can you just speak to if it was denied in a probate and family court, am I hearing you correctly that it's not wise to then go over to the district court to try and vice versa?
Yeah, no. And the important thing to know is that the judges will have your carry in front of them. So they'll know that you had just applied for the same order in a different court.
Thank you for confirming that.
Thank you so much.
So you
Go
guys
ahead,
have
Amy.
our email addresses, I think, and they'll be included in the slides. I noticed a quick typo in one of the hypos that I'll update, and I'll send them out to Stephanie so that she could share it with the group. But yeah, thank you.
Perfect. Thank you so much. One of the questions were if we could share the presentation. We were confirmed with all of you. So I will make sure to send that presentation out with any other resources. But of course, thank you so much for your time today. It was such an amazing presentation. And we look forward to having you again for a future presentation. Thank you.
Before we go, I'll just say if folks are looking for a lawyer and they reach out to me through my email, that's not the best way to do it. The GBLS intake line is, but if you do send me an email, I'll send you that that link since I didn't have it ready for today. And I'll pass you along to the right people. So feel free to do that, but don't expect me to be like, let's go to court tomorrow, because I might not be able to do that.
Perfect. Thank you so much, everyone.
Thank you
Have a
all.
wonderful
Thank
day.
you.
Bye.
Bye.
Bye.